welcome, and I'm going to let Judith Jones introduce the presentation tonight.
Hi to everybody, and so I'm Judith Jones. I'm a lawyer at New Hampshire Legal Assistance, and I am not presenting tonight because I'm not an expert in fair housing, but wanted to just say how happy we are to be here, because in all my work as an attorney in New Hampshire, just very aware of how important NAMI is to everybody in New Hampshire, and just so thankful for the work that you do and the passion that you bring to it. So it had occurred to me that the Fair Housing team and NAMI would make a great matchup with some of the substance that's being presented. So who we have is Attorney Lindsay Lincoln. She's co-director of the Fair Housing team, and she has put together a presentation for today. But I'll also say that the Fair Housing Project, when we look at how the services are offered through NHLA, there's a website, and I have to say that it just shows you how robust this program is. And I think the information that you'll get is going to be key to folks that are served by NAMI.
All right, well, thank you, Judith. So I'm going to go in to discussion about an overview of fair housing law, the federal Fair Housing Act, as well as our state, New Hampshire state law against discrimination, and then kind of hone in on some issues that I think we receive regularly, and I think that would be relevant to you all. As Judith said, you know, our Fair Housing website is a great place to go for resources, information about the work we do, and also just provide our contact information. So if you know a tenant who needs to call us about a housing discrimination issue, can refer them to that site for our phone number. And we, as well as, you know, trainings and outreach that we do, we handle cases directly, you know, represent tenants facing housing discrimination. So we're certainly want to receive any referrals of instances of housing discrimination that you're aware of, to see if there's something we can do to intervene, from providing advice to full representation. So that is my contact information as well. So if you're in need of it, it is there. I'm happy to receive any follow-up questions via phone or email if you have any. I do want to acknowledge that our work is supported by grants from the Department of Housing and Urban Development, and just also make you aware that any statements I make are those of mine and NHLA, and not attributable to HUD. So just an overview, a little bit of background of the Fair Housing Act, which is found in Title VIII of the Civil Rights Act. I included the statutory citation there, but you know, I recognize that that is not something you all may necessarily use, but I did want to at least include it so you're aware of where it is located in our laws. The Fair Housing Act was enacted by Congress in the aftermath of the assassination of Martin Luther King Jr., and it was amended a couple of times to add additional protections. So the original Fair Housing Act, and then there's the Fair Housing Act as amended, which is what I'm going to be talking about, the comprehensive laws that exist today. It is regulated by HUD, the Department of Housing and Urban Development. So HUD will regularly issue guidance material, memos, things of that nature about the Fair Housing Act, and will enforce the act. And I'll speak a bit more about that later. The Fair Housing Act protects against discriminatory treatment, which can discriminatory behavior, which can include disparate treatment and disparate impact. And so those are different types of discrimination, and I'll speak about what each one of those is a little bit later. The Fair Housing Act prohibits discrimination in most housing based on protected classes. And those protected classes are, let's see, here we go. At the federal level, the protected classes include race, color, national origin, religion, sex, disability, and familial status. The there is a case from 2020 that interpreted an analogous law in the employment discrimination context. And the Supreme Court held that discrimination based on sexual orientation and gender identity were necessarily included in discrimination based on sex. So prior to 2020, for example, HUD would not accept a complaint if it was based on gender identity discrimination. Now HUD will accept those forms of complaint after that ruling because the employment discrimination law is analogous to the Fair Housing Act. And so that's a change, a recent shift, an important shift. Sexual orientation and gender identity were covered, protected in classes in New Hampshire prior to that change with the federal law. Also, marital status and age are also additional protections in the state of New Hampshire. So our law against discrimination includes all the federally protected classes and then explicitly lists those 4 other categories that you see. Okay, an important consideration when you're talking about the Fair Housing Act is, okay, what type of housing is covered? And really it refers to dwellings, where someone resides. And it can include a huge range of different types of dwellings, whether it's private housing or government subsidized housing, various forms of rental housing, single family homes, manufactured housing parks, condo associations, assisted living facilities, nursing homes, transitional housing programs, and there are others. So it's just, I do like to underscore the breadth of the law. You know, it covers almost all forms of housing. There are a few exemptions from housing discrimination laws, and those include owner-occupied buildings with 4 or fewer units. So that is a building that has 1, 2, 3, or 4 units, and the landlord, the owner of the building, must reside in one of those units. And so that property, a landlord occupied property with 3 units, for example, would be exempt from housing discrimination laws. Housing operated by religious organizations or private clubs that limit occupancy to members also is exempt in certain situations. For example, if you have housing operated by a particular religion and they want to exclude that housing from that housing members of a different religion, that would be permissible. Single family homes sold or rented without the use of a broker. But I do want to caveat that with that exemption can be defeated in certain situations. So if a landlord is renting one single family home, but owns other rental properties or other single family homes, or uses any type of real estate agent or a broker in the renting or sale of that home, it would bring it under coverage of fair housing laws. So again, I just, want to reinforce the law does cover almost all forms of housing, and the exceptions are limited. And, a particular tenant may not know if their landlord owns other properties. And we would do, a deed search the registry of deeds to see if that landlord owns other properties. So, I wouldn't assume a property is exempt without verification of that through us. So I mentioned that various forms of discriminatory treatment are covered. Disparate treatment and disparate impact are the 2 broad categories, and disparate treatment is direct discrimination based on a person's protected class status. An example of that is a landlord, a tenant who walks in and has a child with them, and the landlord says, "Oh, sorry, this building, I don't rent to kids to live in this building, to families with kids." Directly saying, discriminating based on that person having a child, and that would be the familial status class, the protected class. Disparate impact is also illegal under fair housing laws, and that is when there's a neutral rule, policy, law, or practice that has a disproportionate negative impact on a protected class group. And that will involve often statistical analysis to determine whether there is a disproportionately negative impact. An example of a disparate impact might be we've encountered this before at NHLA, a zero violence policy, for example, that a landlord will evict a household if that household has 3 police responses to their unit within a 12-month period. That type of policy on its face applies to all tenants equally. It doesn't necessarily target any particular group, but the impact of that policy on domestic violence survivors, for example, who are disproportionately women, that policy can have an effect of discriminating based on sex, if it would discourage a domestic violence survivor from calling the police when they need assistance after following an incident of abuse, something like that. So it is important for landlords to consider, obviously, the impact of their policies and how they might need to be adjusted so that they don't create that disproportionate harm. There are also certain exemptions from the protection of the Fair Housing Act that would apply more on an individual level. So if the person is an individual with disabilities who is seeking an accommodation, and I will talk a bit more about that, but if there's someone, say, who has an incident where maybe they have not engaged with counseling for a while, or they stopped taking their medication, and then acted in ways that were disruptive to their neighbors.
That's what your interpretation is. Those weren't her exact words. Those are what she inferred by the way she spoke with you, is what you're saying, though, right? Those weren't her exact words. I'm just going to try to cessate you off of all your medications. That wasn't her plan, right?
I'm sorry.
She told you.
So, no, I'm providing an example of a hypothetical person who has disabilities, whose behavior may be changed if they are no longer taking medication for whatever reason, and behave in ways that are disruptive.
Tell her you went to the doctor because you were having a panic attack and stuff?
No, so a person with disabilities, say, who's taking medication for those disabilities, whatever they are, and then perhaps stops taking those medication, and then because of that failure to consume medication, whose behavior has changed, and therefore maybe acts in a disruptive way, like getting into a fight with their neighbor, or shouting, or destroying property.
They're gonna paint that you missed appointments. Well, I don't.
Gary, perhaps it would be helpful if we could talk about this offline. I think that Lindsay is trying to give a hypothetical example. It would be helpful if we could chat offline if you felt like that would be helpful.
Right. So I will say the landlord could claim okay, just let me finish what I'm saying. So if that incident happens, and then the landlord wants to evict that person for being a threat to the health and safety of other tenants, there is a case, a direct threat to health and safety is an exemption under the fair housing laws. However, this case, Roe v. Sugar River Mills, held that a landlord must entertain a reasonable accommodation request by that tenant, such as, I went off my medication, behaved in a way that I would not behave in were I still on my medication. So they ask their landlord for a reasonable accommodation to either, enter counseling if they weren't receiving counseling before, but engage in some behavior that would reduce the likelihood that disruptive behavior would occur again. And the landlord must entertain such a reasonable accommodation request. And it's the landlord's burden to show that there would be no accommodation that would work to make the tenant a successful tenant. So there is that exception, but reasonable accommodations must be entertained by the landlord if they can address the problem. Other exemptions from the protection of fair housing laws are substantial physical damage to the property of others and current illegal drug use. So that would include things like marijuana use, for example. You can't request a reasonable accommodation for that behavior because it is illegal under federal law. So that those are the exemptions under the Fair Housing Act for individuals. Prohibited practices under fair housing laws. Here are some examples, and I'll go through them. These practices are illegal if they're directed to someone based on their protected class status. So that includes things like refusing to sell or rent. Going back to that example I gave of a person who walks in with their child and the landlord says, sorry, I don't rent to people who have kids. That would be illegal. Terms or conditions with disparate effects, things like redlining, the zero violence policy I mentioned before, where the policy on its face is not discriminatory, but in its application, it disproportionately impacts a protected class group. Steering is illegal. Steering is when it can be a lender, a real estate agent, a landlord, a property manager tries to direct an individual to maybe a particular building, a particular floor on that building, a particular neighborhood based on their protected class status. So something, of the families with kids must live on the first floor, or, Spanish speakers live in this building on the complex, or something of that nature. We're directing someone to a particular unit based on their protected class status. Exclusionary zoning can be illegal if directed to protected class groups. So, zoning a particular area to, if there's a group home with disabilities, and specifically zoning an area that's the only area that property can exist. Retaliation for asserting protected rights is also illegal. That would be a situation perhaps where a tenant believes they've been discriminated against, files a HUD complaint, and then the landlord, a couple months later turns around and tries to evict the tenant because they're a problem tenant, for filing a complaint. Discriminatory advertisements or statements are illegal. Landlords can run into problems when they advertise based on the type of tenant they want in their property versus describing the property. So a statement, in a Craigslist ad that is, oh, this unit is perfect for empty nesters, something of that nature, clearly expressing a preference for, a couple and not people with children. And failure to provide reasonable accommodations or modifications for a person with a disability. And I'm going to talk a lot more about that because those are the bulk of the cases that we handle. I will note, sometimes we get the question, discrimination based on age is prohibited. Why are there older housing complexes specifically for older adults in New Hampshire? State and federal law permit the creation of housing for older persons, and that can be 55 and older housing, where it can be a property could be exclusively 55 and older, or at least 80% of households have one resident who's 55 or older. Also housing complexes that are 62 and older. And if the housing meets criteria for age-restricted housing, it can lawfully exclude based on age and familial status. But that is an explicit exemption from the fair housing laws. Reasonable accommodations in age-restricted housing. I note this because there may be a situation where there's an older adult who lives in maybe a 62 and older property, but needs a live-in aid. Needs someone to live with them full-time at the property. And that person can still make a request for a reasonable accommodation from the 62 and older policy if that live-in aid is, say, 35. So I will at least note that the possibility of reasonable accommodations in age-restricted housing does exist, despite those, how they're designed. Also, admissions and entrance criteria. Sometimes we get questions about these. Housing providers cannot inquire about the existence of a disability or ask about the nature or severity of a disability unless it is to determine whether they qualify for certain dwellings that are only available to people meeting age limits or who have a disability. So if there are maybe priority categories that certain housing authorities may have, or properties for individuals with disabilities, they can ask whether that person would qualify for the unit, but not based on their appearance, for example. It needs to be something that is a standard question that is asked for all applicants to that housing. And even still, the question needs to be limited to the existence, if the person is a person with disabilities, not the specific disability, how long they've had it, things of that nature. All right, so I'm going to now talk a bit more about reasonable accommodations and modifications. And this applies only to individuals with disabilities. An individual with a disability, as that term disability under the Fair Housing Act is defined as is listed here, it's a physical or mental impairment that substantially limits a major life activity, such as someone's ability to walk or talk, sleep, see, think, those types of things. It also includes individuals who have a record of having such impairment or being regarded as having such an impairment. So perhaps someone is not someone who has a disability, but a landlord perceives them as someone with a disability and discriminates against them based on the landlord's mistaken belief. That person could still be protected by fair housing laws from discrimination. Okay, so what are accommodations and modifications? Individuals who have disabilities can request accommodations to allow them to fully use and enjoy their dwellings. So when you're dealing with accommodations, that is a request to change a rule, policy, or procedure to allow the person with disabilities to fully use and enjoy their dwelling. So that might be a request to, which I'll talk about a little bit more because we get these requests quite often. If the landlord has a no pets policy and the person with disabilities has an assistance animal. So requesting for basically an exception from that policy for the person to keep their assistance animal in their home. That would be an accommodation. On the other hand, there are modifications as well. So that's a change to the physical structure of the apartment or common areas to accommodate a disability. An example of that is a person who uses a wheelchair and they need a ramp, installation of a ramp to be able to access the apartment unit. So maybe there's a couple steps up to the door and they need a ramp to be able to traverse, to be able to enter the building. That type of change would be a modification. Accommodations or modifications must be requested, and this can be done at any time. So the landlord, it is not the obligation, nor would it be appropriate for a landlord to say, to request, to speak to the person, to say, oh, I think you have a disability, and, engage with that person in that way. The tenant should be the person who makes the request. The person with the disabilities goes to the landlord and says, I have this is a barrier for me. I have this need and it's due to my disabilities. So that request can be made at any time. It can be made after the service of an eviction notice. In fact, that's a lot of the cases we handle are situations where we're requesting reasonable accommodations after the service of an eviction notice, maybe for an eviction notice for having an animal on the property that is an assistance animal, or a situation where a person's being evicted for a particular result of a mental health crisis, something of that nature, where we might request a reasonable accommodation. Reasonable modifications typically are, a tenant may realize I need this change to the building. So maybe the unit is has a ringing doorbell and the person is deaf, and so they need a flashing doorbell installed. Those are the types of modifications that might be made. Installing grab bars in a shower for stability reasons. Those are examples of modifications. It does not have to be in writing, but this is recommended. And the reason we recommend it is to be clear about what was requested, and when it was requested. So we always advise folks to request accommodations and modifications in writing. That could be via text message or an email. It does not have to be a formal letter, but it does help to have a record later on if the landlord says, oh, well, you only requested X, and the tenant says, no, I requested Y. Having that record can be very helpful. There must be a connection between the disability and the accommodation or modification requested, or the need. So the change in the policy or procedure that the person is requesting needs to be needed because of their disabilities. And the fair housing laws require that requests must be reasonable. And this is these 3 bullet points are really the things that are considered as to whether something is reasonable. So it cannot impose an undue financial burden. An example of an undue financial burden might be a tenant who is requesting an accessible parking spot, and they've all been assigned. And so the tenant says, oh, landlord, you have this, there's a vacant lot that, borders your property. You should purchase that lot and create a purchase that lot and then create a parking lot for me. That would be considered an undue financial burden, and the landlord would be not held liable for refusing that type of request. But the landlord should come back and say, well, I can't do that, but I can put you on the waiting list for a spot. I can reline the lot, something like that. Cannot impose an undue administrative burden. An example of that might be a tenant who has a really severe chemical sensitivity. And so certain cleaning products that a landlord uses aggravates their disability. And so they request that the landlord on a weekly basis provide a list of all the products they're going to use and every product used by other tenants in the building and when other tenants clean their unit. And that type of request would present an undue administrative burden for a landlord. But it would be appropriate, for example, for the tenant to request, to be alerted when cleaning happens. Typically, when does the cleaning happen in the building, so that they can maybe vacate the building during that time. Cannot require, for a request to be reasonable, it cannot require a fundamental deviation from the nature of the program. So that might be a tenant who has certain mobility impairments and they don't drive. So they're asking their landlord to drive them to the grocery store. If that is not a service that landlord typically provides, rides for tenants to shopping areas or grocery stores, that would be, the tenant request would be requesting a deviation from the nature of the program. And that type of request would be unreasonable. But it's important to note that the person with the disability is in the best position to know what would work best for them. So a landlord may say, the thing you've requested is unreasonable for one of these reasons. But I'm willing to offer you this accommodation or this modification. And it's really important for the tenant to engage with the landlord and say, look, my needs, these are my needs. What you're suggesting won't meet my needs. How about this? And kind of engage in what we call it, sort of the interactive process, where the landlord and the tenant talk about what the needs are and how best to meet those needs. And that's is what I speak to on this slide here. The response from the housing provider shouldn't be to flatly deny the request or ignore the request. Those types of things can trigger violations of the Fair Housing Act. It should be an interactive process. If the person's disability is not apparent, or the need for the particular accommodation is not obvious and apparent, the landlord may inquire further, but only as much as is needed to make an informed decision. So the landlord, if it is an individual who has a mobility impairment, they're regularly using a wheelchair, the landlord has seen them around the property, and they ask for approval to install a ramp, the landlord should not be asking for any type of additional verification, because that person's need is obvious. If it is a tenant who maybe has a mental health disability and is requesting an assistance animal in their unit, the landlord could ask the tenant for verification of that need. The landlord can't say, give me your medical records for the last 6 months, but can say, ask for a letter, for example, from perhaps a medical health provider, the health care provider, for verification of the person's disability and the need for the assistance animal. Doctors are not the only professionals. A landlord can't say this letter must be from a doctor. It can be a social worker who has extensive knowledge of that, who's worked with the individual, knows their needs, knows their disabilities, a psychologist, a counselor, something like that. It doesn't have to be a doctor, but really an independent third party who can verify the need. We sometimes get questions about payment for reasonable modifications. Under the Fair Housing Act, a tenant is responsible for the cost of the modification. So in that example I had mentioned about installation of a ramp, under the Fair Housing Act, the tenant would be responsible for paying for the cost of installation of the ramp. It would be the duty of the landlord to approve it, but the responsibility of the tenant to pay for it. If the housing provider is federally subsidized, so a project-based Section 8 public housing, those types of federally subsidized housing providers have to pay for the cost of a modification unless it's an undue financial burden. So that would not apply to a tenant who has a housing choice voucher, a Section 8 voucher in a private apartment. I mean properties where the landlord directly receives subsidies from the federal government. And in such a situation like public housing, a tenant who is deaf and needs a flashing doorbell, the landlord would be responsible for the cost of that installation. But in a private unit, the tenant would be responsible for the cost. And when a tenant is responsible for the cost, there are certain conditions that a landlord can impose for approving modifications. They can, in most situations, require that it be removed and original conditions restored. However, that's only if it is reasonable. If the tenant has, say, widened the doorways of the apartment unit to accommodate a wheelchair, it would be unreasonable because of the cost of such a thing for the landlord to require the tenant to restore the doorways back to their original width, because that doesn't really impact the apartment and is incredibly expensive to revert back. So another example might be a tenant who needs grab bars installed in the bathtub or shower, like I mentioned before. If the tenant needs to install reinforcements in the wall behind the shower to steady the grab bar, the landlord could say at the end, when the person is moving out, you need to remove the exterior bars. They would not be allowed to ask that tenant to tear out the reinforcements that were installed behind the shower. It's not visible, something that doesn't have an impact. So the restoration requirements it must meet the reasonable standard as well. Landlords can require that these changes and modifications be done by a professional who has insurance coverage. They can request that funds be held in escrow to cover costs of restoration. But for individuals, who are of limited means, some type of, payment towards that escrow might be appropriate. Okay, so now I'm going to talk a bit about assistance animals, and that is the broad category under the Fair Housing Act that includes animals that work, provide assistance, or perform tasks for the benefit of a person with a disability, or provide emotional support that alleviate one or more symptoms or effects of a person's disability. So that can be maybe the traditional thought of a person who is blind and has a guide dog. That would be an assistance animal. But also emotional support, someone who has a mental health disability that needs an animal to alleviate the symptoms of that disability. That would, typically known as an emotional support animal. Those would be covered as well under fair housing laws. So again, the accommodation is a request to deviate from the rules. The request must be reasonable, and there must be that connection or nexus between the disability and the request. So, a person who maybe has severe depression and they need an assistance animal to help them get out of bed and follow a routine every day. That might be an example of an assistance animal. Each request is an individualized request. Blanket rules are not applicable. So conditions and restrictions that apply to pets may not be applied to assistance animals. For example, if a landlord has breed, size, weight limit restrictions for pets, those restrictions cannot be applied to someone with an assistance animal. So that's important to keep in mind. Also, landlords cannot charge a pet deposit or an other fee for a person who has an assistance animal. We sometimes get questions about aggressive animals. A landlord says, you can't have that dog on this property because it's an aggressive breed. Those types of denials or considerations of requests have to be individually assessed. And that means this particular dog in question, what is the behavior of that particular animal? If that animal has had no incidents of aggressive behavior, the animal's breed is not relevant. If the particular animal in question has, attacked a child on the property or something like that, that would be an appropriate or could be an appropriate request by the landlord to remove the animal or to deny, if this happened at the prior property, to deny the approval for that person to have the assistance animal. Okay, so if someone's rights have been violated under fair housing laws, if they've been discriminated against based on those protected classes I mentioned at the beginning, there are various forms of relief that fair housing laws provide. So the tenant could get the specific accommodation or modification requested, the next available accessible unit, a request for the landlord to stop the pending eviction, approval to install the ramp. Those types of requests can be included. Damages and costs. So if a person had been denied housing and then they had to rent another unit that was significantly more expensive, for example, the landlord could be liable for a certain period of time for the difference in the costs of those two units, as well as costs like filing fees. So if the tenant files in court and has to pay a filing fee, those types of costs could be a part of the relief for the tenant. Other relief aimed at furthering fair housing, and that can be things like training and monitoring. So there may be an agreement reached where the landlord has to, as part of a HUD investigation, they'll enter an agreement to resolve the case, and that involves them receiving fair housing training for a certain number of years. Or, typically it is common for HUD to monitor landlords. So do, in the next 3 years or 1 year, whatever period it is, doing spot checks, going and making sure that the property is complying with fair housing laws. Also a tenant who can ask for attorney's fees in discrimination cases. And so I mentioned that HUD enforces the Fair Housing Act. They do that by the form of administrative complaints. So a tenant who has been discriminated against can file a complaint with HUD. HUD will investigate the claim of discrimination and also conciliate or mediate between the parties. So during an investigation, HUD would talk to the tenant, talk to the landlord, review documents, look at the different emails that were exchanged, talk to witnesses if there are any of the behavior, and really determine whether that tenant's claim or that home buyer's claim is legitimate. They will also simultaneously try to mediate between the parties. So they will talk to the tenant and say, look, what are you trying to get out of this complaint? What do you want? What type of relief do you want? Do you want money? Do you want your modification to be approved? What are you looking for? And then they will talk with the landlord and say, look, this is what the tenant is looking for. Will you agree to that and enter an agreement? An important thing to note is that there is a statute of limitations. So there is, which is 1 year from the date of when the discriminatory practice occurred or terminated. So the date that the landlord says, I'm not going to rent to you because I don't rent to people with kids, 1 year, the tenant has 1 year from that date to file a complaint with HUD. If they don't meet that 1 year bar, they can still file in state or federal court because that is a 2-year period. So it's just important to note that a tenant can't just wait 5 years and then try and claim relief for an instance of discrimination. For the New Hampshire Human Rights Commission, which is where a tenant would file a complaint based on state law, so a violation perhaps based on marital status. A landlord says, look, there's a couple, I'm not going to rent to you because you're not married. That type of claim would need to be filed at the state level with a Human Rights Commission. And the limitation is 180 days from the date of the discriminatory act. And also, as I mentioned, state or federal court, 2 years. The tenant may also, if the tenant is facing eviction, the Fair Housing Act can be raised as a defense in the eviction action. Yes, this behavior occurred. However, I was entitled to a reasonable accommodation. I requested the reasonable accommodation from my landlord. The landlord refused, but I should have gotten it. I should have been entitled to stop the eviction based on my request. Okay, because I do want to, leave time for folks who have questions. I'm not going to go into a lot of detail about these laws, but Section 504 of the Rehabilitation Act, that is the main way I interact with that law is because it is the law that requires, for example, a landlord to pay, a federally subsidized landlord to pay for a reasonable modification. Title VI of the Civil Rights Act prohibits race, color, and national origin discrimination in federal programs. And so that might be used in a case where a public housing property manager refuses to provide a tenant who speaks Spanish only, refuses to provide that person an interpreter at their recertification meeting or something like that. And also the Americans with Disabilities Act would apply to public accommodations or public areas of the property, which is not often the case. But if there is a large apartment complex and maybe the bottom floor is just the leasing office and anybody from the public can enter into that area, that area would need to comply with the ADA. Okay, I will mention briefly, Maria Eveleth, who is also co-directs the Fair Housing Project, she runs our testing program. And this is just the, the definition of what testing is, but I'll explain it a little differently. It is, we send out people, testers, to determine whether landlords are behaving in discriminatory ways. And that can be, HUD may request that we do a test, or we may maybe see a property that is newly built and we want to make sure they're complying with fair housing laws, or we may receive a request from a tenant who says, this situation happened, but there's not a lot of proof and we want to, bolster the claim before we file with HUD. So we might send out testers who say there's two individuals who are matched on all categories, their rental history, income, things that would be relevant to their tenancy, but there's one area where they're different, and that would be one of the protected classes. So one individual has kids, the other one does not. And so if we're suspecting that there might be familial status discrimination, we would send those two individuals to inquire about an available unit and see how they're treated. And perhaps the person who doesn't have kids is shown more units and told more about the amenities. And the person who does have kids is just given a paper application and shown the door. Something like that might indicate discrimination based on familial status. Okay, and then this last slide, I believe that's the last slide. Yeah, so this is just resources that has our website, our fair housing website, and importantly, 603 Legal Aid. They are, a partner organization. They conduct our intakes and will refer cases to us. So that's an important resource. Also, the state court website, the Fair Housing office in Boston, the Boston office of HUD, as well as the State Human Rights Commission. So those are just some links of important places where you can go to either get information about, legal information or specific information to fair housing in particular. Okay, are there any questions?
Well,
I will
first
stop sharing my screen now so that we can all see each other.
Thank you so much, Lindsay.
Sure.
This was really informative. I learned a lot. So yes, it's great to open up for questions. We want to keep them general, not necessarily specific to a specific situation. But definitely, does anybody have any questions for Lindsay? Oh, go ahead, Maggie. Look like you were, there you go.
So I think you answered my question in your talk, but I know of an individual who is disabled and in a wheelchair for some of the time, has difficulty ambulating and has a couple steps up into her apartment. And I asked about whether modifications could be made, and her answer to me was that the landlord would not do it. So what I'm understanding here is that she could make a request in writing, and as long as she has the funds to do the modification, is the landlord sort of obligated to allow her to do that?
So I can't speak to a specific case. I will say the person would need to demonstrate a need. And so it depends. I would say perhaps it could be relevant how often, what the extent of the need is. Do they really only rely on a wheelchair when they're, going to be in a particular place for a long period of time and need to, take a break. So there are different components to the need. But as a general matter, if the tenant is living in private housing and needs a ramp to be able to access the building, it would be, the landlord would be required to approve that. But I will say, based on what you've already told me, I would probably just recommend that you have that person call 603 Legal Aid or call NHLA directly, so that we can get a bit more information about that. Because I don't want, you know, I don't want to imply I can give you an answer right now based on just that amount of information, but I do think it is something that we would want to hear more about. But so that's just what I would say, to go ahead and recommend and refer that person.
Anybody else have a question? It all seems very complicated, but it was, but really great. And I do agree. I think this was a great presentation for us to offer the folks that we help support through NAMI New Hampshire. I think it really could impact a lot of folks.
Well, I'm glad. I know it is. There are a lot of a lot of nuance and things like that. So I always go back to, if there's a question, contact us, refer the tenant to us. And that's, I just think that's a good course of action. You know, broadly, there are protected classes. People can't be discriminated based on those. But each case has its own, you know, individualized assessment. So
I know our staff that support our information and resource line have been getting lots and lots of calls around housing. Do you have a flyer that you could give us or something, you know, that they could then share with the folks that call? I think that would be
certainly, yeah,
helpful.
I can, if it would be helpful if you could maybe send an email to me. We do have like one-page flyers. There are some pamphlets on our website as well, but if you send me an email with the organization and perhaps how many material, what number of materials they need and an address, we can send those out, no problem.
Okay, or we can even just have the links. That would be great.
Oh, okay, sure. I will email
yep.
you those.
That would be great. Yeah.
I find the link to the NHLA pamphlets, like the pamphlets are amazing. So, and if with people who need to answer questions quickly, there's just a whole wealth there, including consumer fraud and bankruptcy, screening for assisted living, long-term care. So it's a great link. It's a great link to. It's a really great link to have and a great link to share. So
Awesome. Thank you. Okay.
Well, thank you for having us. We appreciate the opportunity and you know, are here for additional trainings. If you know, other specific topics or anything like that, we are available.
No, it's great. Very informative. And I want to thank everybody who joined us tonight. And we will be posting this recording. So if you have other people that you think would benefit from it, you can share the link. I'll be sending out the link with the after we get it tomorrow, probably. Okay, well, have a great night, everybody. Maggie, I'll be in touch.
Thank you too. Have a good night.
thank you.
Hi, everyone.